The state is proceeding on the lesser included offense of attempted indecency with its child sexual contact as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. R0229, State versus Jesse Ariaga. Can I have parties announced for the record for the state?
Opinion for the state of Texas.
Defense?
Raymond Martinez.
And are you Jesse Ariaga?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Ariaga, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
I did. Yes, ma'am.
Counsel, do you waive reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
We are not, Your Honor. We are proceeding forward on an amended count 1 of attempted indecency with child by contact.
Any objection?
No, Your Honor.
We will waive count.
Any objection?
No, Your Honor.
All right, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
I did. Yes, ma'am.
Did you understand you're charged? The state is proceeding on the lesser included offense of attempted indecency with its child sexual contact as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain, yes.
I forgot to also include in the amendment, saying we asked the Your Honor read the amendment also known as the name Jesse Ariaga. Yes, sorry, excuse me.
All right, any objection?
No, Judge.
And are you Jesus Ariaga?
Yes, ma'am.
And are you the same person that is listed in the indictment?
Yes, ma'am.
And do you also go by the name Jesse Ariaga?
Not Jesse R, but Jesse A. Ariaga.
I'm sorry, Jesse A. Ariaga.
Yes,
Is
ma'am.
that also you?
Yes, ma'am.
And you're also Jesus Arizola Ariaga III?
Yes, ma'am.
All right. So did you understand the range of punishment?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
All right, off the record. I see here where you all put state recommends deferred adjudication for a period of 2 years. You all are not allowed to enter into an agreement on the length of probation. So if that's a deal breaker, then
We had an extensive conversation on that, Judge. We understand it's within the court's purview to set the term,
it
although
needs to
I
be
think
removed.
we can still agree to whatever we want to agree to.
All right, so,
And then what I would say is it doesn't bind the court, but
well,
I wanted to have the ability to withdraw my plea if the court was not going to follow that.
no,
recommendation.
you all are not allowed to agree to the term. And it says the state recommends deferred adjudication for a period of 2 years. That shouldn't be here. If y'all want to put down here, this is where your recommendation for 2 years is, but not above the line. So if y'all are trying to bind the court to the length of probation, I'm not going to allow y'all to do that.
That was not the state's intention, Your Honor. Both parties understood that the court has the ability to and to order however long of probation the court deems appropriate. However, I think defense's concern was that we just wanted it known that our intention was the state was recommending 2 years of
Yeah,
deferred
I mean,
adjudication.
For the court, it's there at the bottom of the line. And if you all want to argue and fight for 2 years on the record, you can, but placing it above the line is not appropriate for the court.
I understand, Judge. I'm not going to quarrel. I understand.
No.
I mean, I expected you to say something along those lines. However, my position was we wanted to be able to withdraw our plea if the court wasn't going to follow the agreement.
So you all want me to say 2 years, and I'm telling you right now, you all don't get to dictate or make an agreement to the length of his probation if I follow the plea. And I know that's not anyone's intention, but it just should not be above the line, because this is what's binding upon the
Well,
court.
this is the last thing I'll say about it, Judge. And because I'm not arguing with any of the things you're saying. The issue is if I make certain representations to my client that induce him to accept a plea agreement, I don't want the rug to be pulled out from under him because then he winds up with a 10-year probation instead of a 2-year probation. And so I didn't know any other way to address that other than in this fashion.
All right, so this is what I can tell you, sir. The state and the defense are not allowed to present the court and make it binding on the court that I were to give you a probation term of 2 years. They can argue for the length of probation time. They can argue for certain conditions. The only plea bargain agreement you're able to enter into as a binding contract with the state is whether or not they're in agreement to you having deferred. If they agree for you to have deferred, hypothetically, we can go off the record. Hypothetically, if they were to agree for you to have deferred, and then you come to me and I say, I'm not giving you deferred, I'm giving you a conviction, then I have not followed your plea bargain agreement. If they were to say, I want you to have 3 years in prison, and that's your agreement, and then I were to come back and say, I'm not giving you 3 years in prison, I'm accepting your plea and I'm giving you 4, or I'm giving you more than that, I'm not allowed to do that because that's not a part of your plea bargain agreement. The length of time someone is on probation, that's for the court to decide. Whatever conditions, that's for the court to decide. For example, when you hear me telling people you're to report every month, if I were to tell probation they can report once every 6 months, then those are my conditions. And they only have to report once every 6 months. Do you understand?
Yes, ma'am.
So the state and the defense are telling me that they want you to have 2 years probation, the length of time. They can argue for that, but I don't have to give you 2 years. I can look at it. Maybe I will give 2 years. I don't know. I don't know anything about this case. I don't know the facts of the case. I could give you 3 years. I could give you 4 years. I could give you up to 10 years probation. I don't know because I don't know anything about your case. But they can argue and say they want you to only have 2 years deferred. Do you understand?
Yeah.
All right. So if y'all want to step back and discuss that, you can step back to discuss it. If you still want to go forward with your plea bargain agreement, then this, for a period of 2 years, that's initial, need to be removed from above the line.
Judge, we can scratch it out, Judge.
All right. So if you all want to. All right. We're back on the record. So with regards to the plea bargain agreement, is there any objection from the state or the defense, thank you, to the court removing the words for a period of 2 years next to the state recommends deferred adjudication?
Objection, state.
We do not, Judge.
All right, so the court will remove that portion. And Mr. Ariaga, do you have any objection to the court removing that?
No, I don't.
All right. So you understand the range of punishment?
I do.
And you understand that if you have a plea bargain agreement, the court does not have to follow your plea.
I do.
If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine any witnesses the state would call, and the right to remain silent. Do you understand?
Yes, ma'am.
By entering this plea, you are giving up those rights. Do you understand?
Yes, ma'am.
Do you understand? If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Judge.
Mr. Ariaga, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the lesser included offense under count 1 of attempted indecency with a child by contact. There's a $1,500 fine. The state is recommending deferred adjudication. There's to be Chapter 62 compliance. And of course, you know, there is a registration period related to that of 10 years. And there is to be no contact with the complainant. Do you understand?
Yes, ma'am.
Do you understand that to be the entirety of your plea bargain agreement? Defense, is that the plea?
It is, Judge.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, I do.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years and that you be with the sex offender unit. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offense, the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor, this state offers 6 Exhibit 1 with all attachments.
No objection, Judge.
All right, and state, have you spoken to the complainant or the complainant's family?
We have, Your Honor.
All right, thank you. You may be excused.
Your Honor.
Did you review the waiver and consent to stipulations of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yeah.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We'd like to, judges.
Anything you wish to say on behalf of your client?
Judge, all I can say is that, as you can see from the nature of the plea bargain, there was a lot of exchanging between the parties of information, mitigation, the history of the case, the issues with the child. Unfortunately, she had a very difficult upbringing, losing a parent very young and didn't have the other parent. It just goes on and on. We went through CPS records, we went through counseling records, and it was a hard decision for Mr. Ariaga to arrive at, but he felt it was in the best interest of himself that he not expose himself to a different kind of an outcome. And he's going to have an extensive registration, which doesn't begin until after the term of probation expires, which is why we had such a long discussion about how long his probation was going to be for. He has a clean record for the most part. He's been gainfully employed. He's never missed court, never been late to court, has not had any violation reports. He's ready to put this case behind him. We do want to address one issue regarding his ability to have access to his grandchildren. Because of the nature of the case, obviously there are restrictions in that regard. The parent of those children is here in court. If the court needed to hear from him, or he could advise probation in writing what his desires are in that regard. He's not asking for unsupervised. He just wants to be able to see him as he has been their whole lives. Other than that, Judge, we ask the court to follow the plea agreement.
All right, this is what the court is going to do. Is there anything you wish to say?
No, ma'am.
All right, and what do you do for employment? Not where you work, but what do you do?
I'm a barber.
All right. This is what the court is going to do is a $1,500 fine, time and money. I'm sorry, $1,500 fine probated. Chapter 62 registration. There's to be no contact with the complainant. Regular reporting by Zoom or in person. Proof of employment within 30 days. No employment as a home health care provider or with minors. Regular and random UAs. With the UAs, you can either do a patch. The patch costs more, but you won't have to. It's less time constraints on you. There's to be no unsupervised contact with minors. If he's to have a contact with minor, it'll have to be an approved chaperone by probation. And usually, for example, with regards to your grandchildren, you'll need that person to be the supervised chaperone. Usually it's approved. If it's not approved or there's something with that, just let the court know.
Understood.
And he'll be with the sex offender unit, and the court is going to sentence you to 4 years deferred adjudication. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, good luck to you.